Good morning. I hereby call to order this 8th meeting of the Pennsylvania Public Utility Commission for the year 2017 and ask that you please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Good morning. The first matter on this morning's agenda is the approval of the minutes for the meeting of April 6, 2017, and I will call on Commissioner Sweet, who is the editor.
Thank you, Madam Chair. Excuse me. I've reviewed the minutes of the public meeting of April 6, 2017, and move that they be approved as submitted.
You have heard the motion of Commissioner Sweet. Is there a second?
Second.
Second by Commissioner Powson. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. Moving on to today's agenda, let me just note the absence of our Director of the Office of Special Assistance. We want to recognize and send our thoughts and prayers out to her family. Her father has passed recently, and she is home with her family. So we also ask that you keep her and her family in your thoughts and prayers. So you get me to carry on today's agenda, but we'll be okay. Starting out with our Bureau of Audits, we're going to call up the first case, the Newtown Artisan Water Company. Is there a motion to adopt the staff recommendations?
So moved.
Ooh, excitement in the room. So move on both ends. We'll go with Commissioner Powson on the right and as the motion, and second by Commissioner Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. Moving on to the recommendations from the Office of Special Assistance, starting on page 2 with the matter of Edward Swartz versus Delaware and Hudson Railroad Company, Inc. Continuing on also to the second item on page 2, is there a motion to accept the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0. Moving on to page 3, calling up the matter of Enrico Partners versus Blue Pilot Energy. Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Powson, second by Commissioner Coleman. I would recognize under discussion Commissioner Sweet for his statement.
Thank you. Before joining my staff as legal counsel, Regina Matz was working in the Office of Special Assistance and worked on this case. Please note that she has not advised me in this matter.
Thank you. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. Moving on to Susan Kreider versus Pico Energy Company. Is there a motion to call up this matter for consideration?
So moved.
Is there a second? I will second it. Motion by Vice Chairman Place with my second. Under discussion, I would call on Commissioner Coleman for a joint motion.
Thank you, Madam Chairman. I'd ask that our joint motion be entered into the record as though we read it in its entirety. This formal complaint involves a dispute over an attempted installation of a smart meter at a complainant's residence. Procedurally, exceptions to the initial decision and reply to exceptions have been filed and are pending. The Commission has since learned that the complainant, unfortunately, has passed away. We see no provision in the Public Utility Code or the Commission's regulations that specifically addresses the circumstances where a complainant dies following the filing of exceptions. Nor do we find any Commission cases addressing such a circumstance. However, we note that in civil actions, it appears that the death of a party divests the court of subject matter jurisdiction over claims brought by that party until such time that the deceased personal representative is substituted in his or her place. We believe we should follow this rule of civil court and find that the Commission does not have subject matter jurisdiction to rule on the merits of Ms. Kreider's complaint absent a personal representative substituting for Ms. Kreider. To date, no substitution has occurred. Therefore, we propose to dismiss the complaint for lack of jurisdiction. However, we propose to dismiss the complaint via a tentative order that provides the personal representative period of time to substitute for Ms. Kreider. The dismissal via tentative order serves several important objectives here. A dismissal in the order in this manner reflects that the Commission does not have specific rules governing the substitution of a personal representative for the deceased party. Dismissal in the matter also puts the personal representative formally on notice of the dismissal on jurisdictional grounds and provides the personal representative formally with an opportunity to substitute for Ms. Kreider and receive a ruling on the merits of the complaint. Thus, the proposed dismissal via tentative order ensures that all interested parties and their representatives are afforded due process. Lastly, we do not believe the complaint should be dismissed as moot. We acknowledge that even if the substitution is filed, the Commission would be unable to provide personal relief to Ms. Kreider. However, the primary issue in this case is whether PECO attempted to install a smart meter at the complainant's property constituted unsafe and unreasonable service under Section 1501 of the Public Utility Code would remain. Moreover, we believe that the proceeding is not solely a private matter between the parties following the issuance of the initial decision. The public has an interest that must be protected. In our view, it would not be in the public interest to dismiss the complaint as moot, considering the time and resources the parties and the Commission have invested in this case. Therefore, we move that the formal complaint filed by Susan Kreider, deceased, at the above captioned docket be dismissed for lack of jurisdiction consistent with this motion. The Office of Special Assistance prepare a tentative opinion in order consistent with this motion. A copy of the tentative order be served on the personal representative of Susan Kreider, deceased. And lastly, if a personal representative does not file with the Commission a request to substitute for Susan Kreider, deceased, in the proceeding within 45 days, that the entry of the tentative opinion in order and the order shall become final, and the formal complaint filed by Susan Kreider, deceased, at the above captioned docket shall be dismissed with prejudice.
Thank you. You have heard the joint motion of Commissioner Coleman and myself. Is there a second to the motion?
Second.
Second by Vice Chairman Place. Any discussion on the motion?
Madam Chair,
Commissioner Sweet.
Commissioner Powell and I have a joint statement, and quite frankly, this is a lawyerly disagreement about the reasoning to be applied in this matter. The matter comes to us on exceptions and reply exceptions to the initial decision of the administrative law judges. Following the filing of the exceptions, the complainant, Susan Kreider, unexpectedly passed away. Under these unfortunate circumstances, we believe the complaint is rendered moot. With the untimely death of the complainant, there is no longer a case in controversy, and therefore no claims remain for which the executor can be substituted. Thank you.
Thank you, Commissioner Sweet. Any further discussion on the motion? Hearing none. On the motion, all those in favor say aye.
Aye.
Any opposed?
Opposed?
The motion passes 3-2, noting the dissent of Commissioner Sweet and Commissioner Powson. On the matter as amended, if there's no objection, we will take the previous roll call. Seeing no objection, the matter passes as amended, 3-2, noting the dissent of Commissioner Sweet and Commissioner Powson. The next item is the PUC Investigation and Enforcement versus Morgan Coach and Tours LLC. Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Powson. And under discussion I would recognize, Commissioner Sweet, do you have a statement or?
On which matter?
On page 3, the PUC Investigation and Enforcement versus Morgan Coach. No statement? Okay.
I do not. Thank you.
So on the matter, all those in favor say aye.
Aye. Aye.
Any opposed? No opposed? The motion passes 5-0. Moving on to page 4, at the top of the page, James Michael McGuire versus Pennsylvania Electric Company. Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Coleman. Any discussion? Hearing none, all those in favor say aye.
Aye. Aye.
Any opposed? The motion passes 5-0. Moving on to George Mandeville versus PPL Electric Utilities Company. Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Vice Chairman Place. Under discussion, I would recognize Commissioner Sweet for his motion.
Thank you. The case of George Mandeville versus PPL, excuse me, comes to us through the exceptions of PP&L to the initial decision of Administrative Law Judge Conrad Johnson and the reply exceptions filed by the complainant. Complainant challenged PPL's termination of his service by claiming that the bill sent to him was not his bill after PP&L placed an arrearage of $8,747.77 on his present account from a prior account. Although complainant did not include any details in his formal complaint, he testified at the evidentiary hearing that the arrearage in question had been discharged in bankruptcy and that he had not even lived in the PP&L service territory for 5 or 6 years prior to when the amount was added to his bill. However, the complainant did not provide any documentary evidence supporting either conclusion. Therefore, it is arguable the complainant did not make a prima facie case, which is the first requirement that must be met to satisfy the burden of proof. On the other hand, the record shows that PP&L presented no evidence of when the transferred charges accrued or at what address they accrued. Consequently, it does not appear that the current record in this case is adequate to render a decision on the arrearage in question. Moreover, I do not believe PP&L was given a meaningful opportunity to respond to all the issues raised by the complainant at the hearing. From the face of this formal complaint, the only 2 issues were that the complainant believed he was being asked to pay a bill which properly belonged to another customer, and that his service was either in danger of being terminated or already had been terminated. It is not unusual for a self-represented complainant to testify beyond the 4 corners of the formal complaint. There is no problem with allowing such testimony as long as the respondent is given a full and fair opportunity to address the new allegations, even if this requires additional hearings. In this case, the complainant was permitted to provide testimony beyond what could have reasonably been contemplated by reading the complaint. PP&L asked that it be given an opportunity to provide clarifying evidence on the complainant's bankruptcy claim, and this request was denied. Furthermore, the presiding officer at hearing requested of PP&L to get back to him on what the complainant was being charged for before he wrote his decision. However, the record was closed without PP&L having been given the opportunity to do this. Accordingly, this case should be remanded to the Office of Administrative Law Judge for additional proceedings as appropriate, including but not limited to an opportunity for an additional evidentiary hearing where PP&L is given an opportunity to present an informed response to the testimony provided at the first evidentiary hearing by the complainant. As always, the parties are encouraged to work together towards an amicable resolution to this dispute. Therefore, I move that the initial decision of Administrative Law Judge Conrad Johnson be vacated, that the matter of Mandeville versus PP&L filed at docket number C 2015-251-2838 be remanded to the Office of Administrative Law Judge for proceedings consistent with this motion. And thirdly, that the Office of Special Assistance prepare an appropriate order. Thank you.
You have heard the motion of Commissioner Sweet. Is there a second?
Second.
Second by Commissioner Powelson. Any further discussion on the motion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. Without objection, we'll take the previous roll call on the matter as amended by the motion. Hearing none, the matter passes 5-0. The last 2 items under the recommendations for the Office of Special Assistance, starting on page 4, is the Verizon Pennsylvania LLC and Tenney Journal Communications. And on page 7, at the top of page 7, the only item left is the South Canaan Telephone Company, Inc. and Level 3 Communications. Is there a motion to adopt the last 2 recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. Moving on to page 6, under the Bureau of Technical Utility Services, we're going to take this in omnibus fashion. On page 6, starting at the Tri-State Household Goods Tariff Conference, Inc., all those on page 6, including that on page 7, page 8, ending at the Columbia Gas of Pennsylvania, Inc. case. Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Powelson, second by Commissioner Sweet. Any discussion on these issues? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. Moving on to page 9, under Law Bureau, the two matters on that page, Pennsylvania American Water Company and Verizon Pennsylvania LLC. Is there we'll take the first matter first. Pennsylvania American Water Company, is there a motion to adopt a staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. On the second matter under Law Bureau, the Verizon Pennsylvania LLC, is there a motion to adopt a staff recommendation?
So moved.
Is there a second? I will second it. Motion by Vice Chairman Place, and I will second that. Under discussion.
Chairman, I'll be voting in concurrent result only.
Thank you, Commissioner Coleman.
Madam Chair, good morning. I will also be concurring in result only on this case.
Thank you, Commissioner Powelson. So all those in favor say aye.
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 Any opposed? Hearing none, we will note that Commissioner Powelson, it passes 5-0, noting that Commissioner Coleman and Commissioner Powelson are concurring in result only. Moving on to page 10, under the Office of Administrative Law Judge, calling up the first matter, Eric Richmond versus Respond Power LLC. Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Sweet. Under discussion, I do have a statement that I would like to submit in its entirety for the record and just summarize it. Before the commission is the initial decision to the complaint filed by Eric S. Richmond against Respond Power LLC and Major Energy. This proceeding draws attention to the delicate balance I believe this commission must achieve when implementing the dual mandates under Chapter 22 and Chapter 28 of the Code, and that is to foster retail competition and to maintain appropriate universal service policies. Here, the complainant's failure to review his utility bill has likely resulted in the exhaustion of subsidy dollars quicker than if he had known his supply charges, or resulted in an increase in the universal service program costs for the utility. Either outcome, in my view, is not ideal. I encourage electric and natural gas distribution companies to continually consider policies that provide cost-effective universal service programs which do not unduly harm the state's retail energy supply market. Additionally, I encourage Pennsylvania residents to review all retail supplier enrollment materials and to monitor utility bills on a routine basis in an effort to make sure bills match the customer's expectation for both retail supplier and utility service. Any further discussion? Hearing none. All those in favor say aye.
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 Any opposed? Motion passes 5-0. On the next matter, the E. McCauley versus Pennsylvania Electric Company, is there a motion to call up this matter for consideration?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Coleman. Under discussion, I would recognize Commissioner Sweet for the joint motion.
Madam Chair, did you want to handle that, Commissioner Powell, or do you want me to?
Commissioner Sweet, I'd be honored to read
I
the
would not
joint
want to
statement.
deny you such an honor, so please.
I'm feeling the love.
Yeah.
Commissioner,
I yield up my time to
Commissioner Powelson.
Thank you, Madam Chair. Before the Commission for consideration of disposition is the initial decision of Administrative Law Judge Mary Long in the above captioned proceeding. The complainant, E. McCauley, filed a formal complaint with the Commission against Pennsylvania Electric Company on July 18, 2016, alleging that she was having persistent reliability and quality of service problems related to her electric distribution service at her property. Specifically, she claimed that she was experiencing excessive intermittent interruptions of service and that Penelec's customer service representatives were not properly trained to respond to her concerns. Penelec filed an answer on August 24, 2016, denying the material allegations of the complaint. The initial decision found that the complainant sustained her burden of proving that Penelec failed to provide her with reliable service and imposed a civil penalty of $5,000. Additionally, it was found that the complainant did not sustain her burden of proving that the operation of the utilities call center was unreasonable or the call center representatives were not reasonably trained. No exceptions were filed. In this particular case, the complainant contends that she has a long history of reliability problems with her electricity service. Given the number of sustained outages experienced by the complainant, we find that Penelec violated Section 1501 of the Public Utility Code by providing unreasonable service. Therefore, we affirm the initial decision with regard to the sustained outages and agree with the imposition of a civil penalty. However, while the record affirms the sustained outages experienced by Ms. McCauley, the cause of each momentary outage is still unclear. The company dispatched field technicians to the service address for further investigation, but in each instance, Penelec was denied entry onto the property by the complainant. By her own actions, Ms. McCauley prevented the company from fully exploring why additional outages might have occurred, thereby preventing both a possible solution and a possible defense for the company to her allegations. Because of this, we are forced to conclude that Ms. McCauley has not carried her burden of proof regarding the momentary outages. Should Ms. McCauley continue to experience these outages, we strongly encourage her to allow the company access to her property in order to access the situation, noting that without such a comprehensive assessment, this commission may be unable to determine what is causing the alleged outages. The ALJ imposed a civil penalty of $5,000 based on her findings that Penelec had provided inadequate service regarding, one, its violation of a 2015 commission order regarding the same circuit, and second, the persistent interruptions of service, both sustained and momentary. And as we are reversing this finding regarding the momentary outages, the civil penalty will be reduced accordingly. We find that the civil penalty of $2,000 is an appropriate level under the guidelines of our policy statement under Section 52 PA Code, subsection 69.1201. Furthermore, we note that in similar proceedings involving outages on complainant circuits, the Commission referred the matter to the Bureau of Technical Utility Services for further analysis to take whatever action deemed necessary. Therefore, this morning, we direct that a copy of the opinion and order be served on TUS so that the Bureau can continue to monitor and assess the circuit providing service to the complainant's address. Therefore, this morning, we move that first, the initial decision of Administrative Law Judge Mary Long is reversed insofar as it finds that E. McCauley sustained her burden of proving that the momentary outages she alleges constitute unreasonable service. And second, that the initial decision of Administrative Law Judge Long is affirmed insofar as it finds the sustained outage experienced by Ms. McCauley constitutes unreasonable service. And third, the Pennsylvania Electric Company shall pay a civil penalty of $2,000. And fourth, that a copy of the opinion and order be served on the Bureau of Technical Utility Services. And that finally, the Office of Special Assistants prepare an order, opinion and order consistent with this motion. Thank you, Madam Chair.
Thank you, Commissioner Powelson. You have heard the joint motion of Commissioner Powelson and Commissioner Sweet. Is there a second to the motion?
Second?
Second by Commissioner Coleman. Any discussion on the joint motion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. On the matter as amended, without objection, we'll take the previous roll call. Hearing none, the matter as amended passes 5-0. And that concludes the regular agenda, and we are moving now on to the carry-in agenda. With that, we'll call up, on the first case is the PUC Investigation and Enforcement versus Metropolitan Edison Company and North Heidelberg Sewer Company. Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second,
There's,
third, fourth.
I heard Commissioner Powelson for the motion. I heard Vice Chairman Place for the second. I heard another third down there, Commissioner Sweet. So, but we only take the first and the second, unfortunately. Any discussion on the matter? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. The second matter on the carrying agenda under the Law Bureau is the certification of distributed antenna system providers. Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Powelson. Under discussion, I would recognize Commissioner Powelson first.
Thank you, Madam Chair. Before the commission are the petitions for reconsideration by two distributed antenna system operators, commonly referred to as DAS providers. The Law Bureau recommends that we deny the petitions. I fully agree with the Law Bureau recommendation that the petitions for reconsideration should be denied here this morning. However, to the extent that it assists the DAS operations in better understanding our DAS order here this morning, I believe that we should also briefly address the DAS petitioners' three main arguments, and they are as follows. The first argument is the commission order did not analyze whether DAS operators are furnishing cellular radio telecommunications service, CMRS, but rather analyzed whether DAS networks are utilized in the furnishing of CMRS service. Now, this interpretation is neither an accurate or fair reading of the DAS order, where we clearly concluded that DAS networks should be defined by their functionality, or rather the service they furnish, not by any particular configuration of their facilities. Moreover, the contrast between an entity operating facility that furnishes CMRS service and an entity that furnishes CMRS in a distribution is without a difference. Using this one description or the other does not affect the legal analysis, and the legal conclusion remains the same. The second argument that has been used by the petitioners is the Commission's DAS order does not adequately explain how DAS operator service are radio communication services. For the record, the petitioners argue that the radio frequency, or the spectrum itself, is controlled by retail wireless provider, or WSPs. I respectfully disagree. It is inaccurate to argue that DAS networks may facilitate CMRS, but do not furnish CMRS. The DAS operators nowhere explain how a WSP controls the signal. The better analogy is that DAS networks are the entry and exit ramps of the CMRS highway, and when viewed in this light, are furnishing that service in tandem with WSP. The third argument that the petitioner used was the Commission completely overlooked the narrow scope of the FCC's wireless infrastructure order and Pennsylvania's Act 191 existing structures statute. For the record, from the perspective of the DAS operators, the main benefit of the wireless infrastructure order was to extend the benefits of the FCC's shot clock order to DAS networks. The scope of the FCC orders was not limited to existing structures. While the DAS petitioners continue to complain about their loss of certificates of public convenience, these grievances cannot drive our decision here this morning. Rather, our resolution must be based on the facts and the law, including the Public Utility Code, and not upon a desired outcome. Since our DAS order was issued, the FCC has now opened a docket to explore further liberalization of municipal and other rules affecting wireless deployment, which is focused on shortening the deployment timeframes and relevant issues for DAS providers. Nowhere has the FCC suggested that any wireless carrier should be vested with eminent domain or possess the right to override local zoning requirements. Thank you, Madam Chair.
Thank you, Commissioner Powelson. Recognize Vice Chairman Place.
Thank you. Madam Secretary, I'd like to place my statement on the record as if I had read it in its entirety. Before us for disposition are the petitions for reconsideration of the Commission's March 17, 2017 order that were submitted by Crown Castle and Next to Net Systems. I will not read my statement in full. However, I believe that the petitions for reconsideration present credible and persuasive arguments delineating why the Commission's order in this matter should be substantively reconsidered and materially changed. I agree with Crown Castle and Extenet, both distributed antenna system operators, that the threshold standard is met here for granting substantive reconsideration of the Commission's order. Both Extenet and Crown Castle persuasively argue that the March 2017 order did not properly interpret or apply Section 102.2.4 of the Public Utility Code. In its ultimate conclusion that the operators of DOS networks are providers of commercial mobile radio services and thus are not public utilities under Pennsylvania law. As Extenet points out, the March 2017 order focused on the utilization of DOS facilities and networks in reaching this conclusion. Extenet submits that it may be accurate to state that DOS facilities or networks are used to facilitate CMRS because wireless service providers like T-Mobile and Sprint do indeed utilize DOS networks on a wholesale basis to provide retail CMRS. However, the WSP's wholesale utilization of DOS facilities and networks does not transform the DOS operators into CMRS providers and does not otherwise equate such DOS operators to WSPs. Extenet's reconsideration petition goes through a detailed listing why the statutory interpretation is not sustainable. This includes the argument that under the applicable statutory language, even if an entity is providing CMRS but is otherwise a public utility, then the statutory exclusion from public utility status does not apply. If a DOS operator's landline point-to-point wholesale transport facilities and services that carry multi-jurisdictional traffic for both CMRS and non-CMRS customers are already subject to or can be covered under a competitive access provider public utility classification by applying the otherwise public utility term of the statute, the DOS network operator cannot find itself excluded from this classification under Section 102.2.4 simply because its network utilizes antennas and radio frequency equipment. As the petitions for reconsideration state, although DOS network operators lack the essential resources and critical functionalities, including the absence of any FCC licensing to provide CMRS, the March 17 order essentially finds that they do not furnish such services to mobile end users. The DOS petitioners have argued that this result is not legally or factually sustainable, and I agree. Therefore, I believe the petitions for reconsideration should be granted and the March 17 order should be substantively revised. Thank you.
Thank you, Vice Chairman Place. I also have a statement for the record, in case you haven't heard. We're looking to consider the petition for reconsideration of the previous decision under the standard of the Dewey versus the Pennsylvania Gas and Water Company case. And while I continue to believe that the Commission should continue certifying the DAS providers as wholesale telecommunications under the state and federal law, my review does not convince me that there are any new or novel matters or previously overlooked facts or arguments warranting reconsideration under the Dewey standard. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed?
No.
The motion passes 4-1. Noting the dissent of Vice Chairman Place. That concludes all of the agenda for the carry-in agenda. Before we close out today's meeting, I do want to recognize Vice Chairman Place for remarks on Electric Safety Month.
Thank you, Chair. In conjunction with National Electric Safety Month, I would like to take this opportunity on behalf of the Commission to focus attention on electrical hazards at home and at work, and for contractors and homeowners across the state to take steps to avoid accidents and injuries. On most days, we take electrical safety for granted, but electricity is unforgiving and a moment of inattention can have devastating consequences. According to data compiled by the PUC's Electric Safety Division, an average of 24 serious injuries and 6 deaths occur each year in Pennsylvania. Of these, 48% of these serious injuries and 62% of the deaths are related to contractor activities. As a first step to address these risks, it is critical that contractors operating close to power lines contact the local utility to develop a safety plan. Utilities have electric safety sections on their websites to provide easy access to contact information, electric safety instructions, and educational resources for this precise purpose. Links to these vital resources are also available in the electric safety section of the PUC's website. Precautions while working around power lines include, and please bear with me as I delineate these because I think it is worth noting in some specificity. Please look for wires before beginning any type of construction work. Pre-job planning is a major factor in preventing accidents. Never use ladders with metallic rails near power lines. Use a spotter where views may be obstructed to ensure a safe working environment. For voltages below 50 kilovolts, individuals, tools, and other objects may not come within 10 feet of an energized line. Distances are increased for voltages above 50 kilovolts. Utilities should be contacted to verify the voltage of power lines within the job site before beginning work. Crane and derrick operators must contact the utility owner and adhere to OSHA rules when working within 20 feet of power lines. Utilities stand ready 7 days a week to send a representative to the job site to help make this work site safe. It is best to plan ahead and give the utility as much notice as possible so that project delays can be avoided. Homeowner safety is equally important. Similar to contractor safety guidance, the Commission and Pennsylvania's electric utilities have important safety guides on their websites to help ensure a safe environment in and around your home. Utility representatives can also visit your home to ensure precautions are in place before any work begins near a power line, including de-energizing your line or placing protective sheathing on electrical wires to protect against contact. Additional precautions include always look for wires before beginning any type of work or maintenance around your home. Call your local utility to develop a safety plan when working near wires or to identify wire voltages. Again, keep yourself and all ladders and tools at least 10 feet from power lines. Always make sure that if the ladder were to fall, it would not come in contact with power lines or electrical equipment. In any event, the use of non-metallic ladders is strongly encouraged. This reminds me of anecdotally, I did this on my farm last year and probably barely avoided a serious injury. Pool skimmers, paintbrush extensions, and other similar tools should be of a non-conducting material and must be kept a minimum of 10 feet from power lines for voltages less than 50 kilovolts. Do not attempt to touch or trim trees that are closer than 10 feet to any power line for voltages less than 50 kilovolts. Downed power lines can present a significant risk. Stay at least 30 feet from any downed power line and do not approach the utility pole or anything touching the line. Always assume a power line is energized. The safest technique for moving away from a downed line is to shuffle with your feet together and on the ground. Do not touch any person, vehicle, or equipment that is in contact with electrified objects. If it is necessary to leave a contacted vehicle, the person should jump clear of it so that no parts of the body are in contact with equipment and the ground at the same time. Additionally, improper use of portable generators can lead to electrical fires or poisonous carbon monoxide gas. Never use generators indoors, in your garage or basement or any enclosed space. To ensure that no underground electrical wires or the utility facilities are located beneath an area being excavated, contractors and homeowners are reminded to always contact Pennsylvania's one-call program by dialing 811 at least 3 days prior to digging. Every Pennsylvania utility participates in PA one-call. Lastly, this commission continues to promote enhanced electric safety awareness, including enhancements to the electric safety section of the PUC website, highlighting utility companies' safety resources, and links for contractors and homeowners to submit make-safe requests, strongly encouraging utilities to provide free or limited cost responses to make-safe requests by contractors and homeowners in order to ensure that these important services are utilized and work sites are safeguarded. Promoting clear and easy access to safety information on utility company websites, including education materials with electrical safety and a streamlined process for make-safe requests. recommending proactive outreach by utilities to contractors and homeowners in their service areas, educating both groups about safe practices around electrical facilities, and expanded use of social media by the PUC and utilities to communicate about safe practices. It is the Commission's goal to make a significant reduction in the number of electrical safety and injuries and deaths. The Commission will continue to work collaboratively with utilities to identify risks, educate contractors and homeowners about the potential dangers of working near live electrical lines, and promote safe practices. Thank you very much.
Thank you, Vice Chairman Place, for those remarks on Electric Safety Month. Before we close out, before we adjourn, I just want to take a moment to recognize the many people that have been working to repair damage caused by severe storms that have swept across our state on Monday and Tuesday of this week. Winds topping 85 miles per hour, along with the 4 confirmed tornadoes, blasted across western Pennsylvania and the northern tier of our state. And at the height of the storm, more than 70,000 households were without power. In fact, this week's storm, with their extremely high winds, had a much greater utility impact than the past several major winter storms, demonstrating the power of Mother Nature. We appreciate the dedication of thousands of power company crews and contractors from Pennsylvania and nearby states who have been working around the clock to restore service to hard-hit communities. We are also grateful for the maintenance crew and the emergency responders who worked during and after the storm to remove downed trees and other storm debris so utility crews could reach hard-hit neighborhoods. And last but not least, we thank our consumers for reporting outages and safety hazards and for their patience as repair crews continue, especially in the communities such as Towanda, State College, St. Mary's, Clearfield, Du Bois, Oil City, and Warren, who faced the worst of the storms this week. This storm seems to serves as a reminder that we must always pay attention to the weather, especially when severe storms are forecasted, and prepare for the disruption those storms can cause. So once again, I just want to thank all of those that worked hard on our storm responses this week. And if there's nothing else to come before the commission, I would say that our meeting is adjourned. Thank you.